I thought I moved here for peace. Instead, I got a $500 fine for fishing with my daughter, and a silent warning, don't ask questions. The way they watched from across the street, like I'd broken some unspoken rule, stuck with me. Who's really in control, and what happens if you push back? Stick around. Because I'll show you 5 simple moves that bought me time, allies. Because a way to fight back, no law degree needed. I never expected a fine to show up in my mailbox, especially not one for something as simple as fishing with my daughter. But there it was, a pale, official envelope, heavy in my hand on a Saturday morning, stamped with Vista Estates HOA. Not the city, not the county, just the same group that tells you how tall your bushes can be. My daughter was already asking if we could go back to the lake. I didn't have an answer. Because I hadn't even opened the letter yet. Inside, the violation notice was wrapped up in 3 paragraphs of polite language and 1 line that landed like a punch: unauthorized use of community fishing access, penalty assessed, $500. Future violations may result in loss of privileges. No explanation, no map, no bylaw number, just a vague threat. The only contact info was for HOA board relations, buried at the bottom. I scanned the page twice, hoping I'd missed something obvious. Nothing. What hit hardest wasn't just the money. Though $500 was most of my grocery budget for the month, it was the way the letter felt, like an accusation and a warning, all at once. I stood on the porch, the letter in my fist, and glanced up to see a neighbor walking her dog. She looked right past me, like I was invisible. That's when it really sank in, this wasn't just about a fine. It was about control, about making sure nobody asked questions. I called the number on the notice. Straight to voicemail. I left a message. Then I sent an email to the address they gave. Days went by. No answer. My daughter kept asking if we could go back to the water. All I could say was, I'm working on it. I started digging through every HOA paper I'd saved since moving in. Somewhere, there had to be a rule, a line, something that explained what I'd supposedly done wrong. I pulled out the thick folder from closing, full of welcome to the neighborhood letters and lists of rules. Some of it was about trash can placement, some about parking. Nothing said a word about fishing on the lake. The more I looked, the more frustrated I got. If there was a rule, why wasn't it in writing? And why was the only evidence a letter with no details, no dates, no citation, just a demand for money and a warning to stay quiet? I started calling neighbors, asking if they'd ever seen a rule like this or gotten a similar fine. Most people changed the subject or shrugged. One neighbor just said, "It's probably best not to make waves." That silence felt deliberate. Here's the first thing nobody tells you: when you get a fine like this, your real first step isn't to argue or pay. It's to compare the fine to 3 documents: your property deed, the CC&Rs, covenants, conditions, restrictions, and the HOA's official rules. If it's not in black and white, you have a right to ask questions. Most people never do. Back to that letter. It didn't quote a single bylaw or show any legal citation. Just community standards and a penalty. That's a red flag. I looked for any reference number or signature, nothing. The whole thing was designed to look intimidating but gave me nothing concrete to challenge. I started to realize this wasn't just an honest mistake. The system is built to make you feel isolated and powerless. The big envelope, the official-sounding language, the lack of real details, it's all meant to get you to pay up and move on without asking questions. But the more I pressed, the clearer it became that nobody really knew what rule I'd broken. It was just the way things are done. That's when irritation turned into something more. I wasn't just upset for myself. I was angry for anyone who ever got one of these letters and just paid out of fear. I thought about what it would mean if I just rolled over, what lesson that would teach my daughter, and what it would mean for the next family who wanted to fish on the lake. So, I kept at it. I made a list of questions and sent another email. I started writing down everything, dates, who I talked to, what they said. I checked every page of the HOA handbook. Still nothing about fishing restrictions, nothing about fines for using the lake. When you get a letter like this, you have to treat it like a puzzle. Every missing detail, every vague phrase, every lack of citation is a clue. I realized the HOA counted on people not looking too closely. They expected silence. But the more I asked, the more obvious it became that their letter had no legal citation and no specific bylaw number, just a threat dressed up to look official. If you're in this spot, here's what matters: don't just pay. Don't just accept the fine. Start by checking your deed, your CC&Rs, and the HOA's rules. Keep every letter, every email, every voicemail. Write down every conversation. These are your tools. That first rush of clarity, knowing I wasn't alone and that the letter didn't hold up under basic scrutiny, gave me a sense of control again. I told my daughter we'd wait a few days, just to make sure. She was disappointed. But I wanted to be sure we weren't missing something important. So if you ever get hit with a fine that doesn't make sense, remember, the first thing to do isn't to panic or pay. The first thing is to check your paperwork. Sometimes, the answer is already sitting in your own files, waiting for you to notice what's missing. And that's where the real story starts to shift. Most people shove their closing papers into a drawer and forget about them. I was the same, until the HOA fine forced my hand. I sat down at my kitchen table, folders stacked high, determined to find out if the answer was buried in all that paperwork. The deed was there, marked settlement/deed, keep, its heavy envelope wedged between old appliance manuals and a pile of birthday cards. I pulled it out, hands a little shaky, and flipped through the dense, formal pages. Legal documents don't make it easy. The language is stiff, packed with words like hereinafter and heretofore. But then I found what I was looking for, tucked under rights of access and use, riparian access and recreational privileges for property owner and immediate household shall be preserved unless heretofore conveyed. That one line jumped out at me. It wasn't just boilerplate, it was specific. It named my household, my lot, and my right to use the water. I slid the deed next to the HOA's violation notice on the table. The contrast was obvious. My deed had signatures, notary stamps, and my address spelled out. The HOA letter was generic, no name, no parcel number, just resident. Their fine demanded $500 for unauthorized use of community fishing access, but never once did it mention an actual bylaw, date, or any legal reference. It didn't even have a real signature, just a printed block at the bottom. That's when I realized what most people miss: recorded property documents and easements are primary evidence of rights. Later HOA newsletters don't automatically override a recorded deed. Deeds are filed at the county, witnessed, and stamped. HOA memos, by comparison, are often just internal policies. The law in most states gives strong legal weight to recorded documents, though outcomes can vary depending on your state and the details of your case. The deeper I looked, the more the differences piled up. The deed listed my right to fishing and recreational use from sunrise to 1 hour after sunset. It had a date, years before the HOA ever sent out their first newsletter. Every important section had a witness line, a notary stamp, and a real signature. The violation notice? Nothing but vague threats and policy language with no citation. No city code, no reference to a specific rule, no evidence that any actual law had been broken. I kept thinking about how easy it would have been to miss this. If I'd just paid the fine and moved on, that line in my deed would have stayed buried. Most people never read their deeds after closing, they assume the HOA's word is final. But the truth is, those old papers matter. They're not just souvenirs from a stressful day at the title office. They're legal evidence. And they can make all the difference when someone tries to push you around. There's a reason HOAs rarely mention your deed when they send a violation notice. They hope you'll be too overwhelmed or too busy to check. They count on most people not bothering to read past the second paragraph of a dense legal document. But when you do, you start to see how much of their authority is based on habit, not law. I wanted to believe there was a simple fix. That I could call someone, point out the line in my deed, and be done. But it's never that easy. The HOA sent their letter hoping I'd pay quietly. When I started quoting my deed and asking for the exact rule I'd supposedly broken, the tone shifted. The calls stopped. Emails went unanswered. The office manager, who usually loved to talk about community standards, suddenly had nothing to say. That's when it really hit me. This wasn't about a simple mistake, it was about control. The HOA's notice was designed to intimidate, not inform. It relied on vague language and the hope that nobody would check the original documents. But the moment I did, the balance shifted. I had proof of my rights. They had a template letter. If you're in this situation, here's what matters: don't get lost in the legal jargon. Look for specific, concrete details. Is your name on the document? Is there a date? A signature? Does it reference your property and spell out your rights? Compare that to whatever the HOA sends you. If their notice doesn't cite a law or show a real bylaw, that's a red flag. People ask me all the time, why bother fighting? Isn't it easier to just pay? Maybe. But if you don't challenge a bogus fine, you're inviting more. HOAs send out these notices because it works. Most people pay without question. But when you push back with real evidence, you force them to show their hand. The real lesson here is simple: if you get a notice, don't pay immediately. Pull your deed and compare. That single habit buys you time and leverage. Sometimes, the clues are right there in the paperwork, but there's another side to this: the violation notice itself, the way it's written, what it leaves out, and how it's designed to make you doubt yourself. That's where things get interesting. When I sat down with that violation notice, I stopped treating it like a warning and started treating it like evidence. The more I read, the more I realized these letters are built to look intimidating. But what really matters is what's missing. I learned to scan every violation notice for 4 things: a bylaw or ordinance citation, a specific date, time, and location of the incident, attached evidence like photos or witness statements, and an actual signature from a real person. That's the checklist you want to keep in mind. Each one matters. A real citation lets you look up the rule for yourself. An incident date and location show what you're actually accused of. A photo is concrete evidence. And a signed letter means someone is actually accountable. Research shows HOAs often skip these steps, relying on vague fines and inconsistent enforcement to keep people from pushing back. Looking at my own notice, I realized it failed every part of that checklist. The violation: unauthorized fishing activity in community space. No bylaw number. No city ordinance. No mention of which space, what day, or even what time I was supposedly out there breaking the rules. There wasn't a single photo attached, no witness name. And the signature block was just a printed HOA board relations. Not my name, not my lot number, just resident. It felt like it could have gone to anyone on my street. I started highlighting every line that sounded official: community policy, standards of conduct, future violations will result in escalation, but none of it pointed to anything I could actually check. There was no page number from the handbook, no reference to city code, not even a map to show where I was supposedly in the wrong. The letter was all bark, no bite, just enough legalese to make you second-guess yourself, but nothing you could actually verify. At first, I wondered if maybe I was missing something buried in the mountain of HOA paperwork. I dug through the welcome packet, the rulebook, every newsletter from the past 2 years, nothing about fishing on the lake, nothing about needing a permit. And certainly nothing about a $500 fine. The more I searched, the more it looked like the notice had been written to sound scary, not to inform. I called the HOA, asking for the exact bylaw I'd supposedly violated. The answer came back, "It's in our general standards." No section, no number, nothing I could look up. I called the city clerk and asked if there was a local ordinance about fishing in the development's lake. She told me, "That's up to your deed or the HOA agreement. No city rule." That's when it really sank in. These letters are designed to make you feel powerless, hoping you'll be too busy or too anxious to ask real questions. I started searching online, just to see if I was alone in this. Turns out, I wasn't. HOA forums are full of people posting nearly identical letters, always threatening fines, rarely providing details. The pattern is everywhere: vague accusations, no evidence, no real citations. Researchers have found that HOAs often rely on form letters and ambiguous community guidelines to scare homeowners into compliance. It's not always illegal. But it's a tactic, one that depends on people not knowing their rights or not having the time to check. One neighbor told me he'd gotten a letter for unauthorized landscaping. When he asked which rule he'd broken, the board backed off, not because he was special, but because he'd asked for specifics. That's when I realized, these notices aren't about sharing information. They're about seeing who will pay without a fight. I kept coming back to the same 4 missing pieces: no citation, no date or location, no evidence, no real signature. It's a pattern. If you get a letter that skips all 4, it's almost always a scare tactic. They're counting on you to panic, pay, and move on. But if you start asking for details, what rule? What date? Where's the evidence? Who signed this? The tone usually changes fast. Sometimes, the board goes quiet. Sometimes, they double down. Either way, you've signaled that you're not just another easy target. I started writing down every call, every email, every conversation. I realized the letter was meant to keep things vague so that I'd never have a solid place to push back. But now, I had my own checklist, and I wasn't letting it go. It's easy to feel alone when you get one of these letters. They're designed that way. The language is formal, the threats are vague, and the lack of details is intentional. The research backs this up. Inconsistent and arbitrary fines are a common HOA problem. And most boards rely on silence and confusion to keep their authority. But the moment you start treating the notice like a puzzle, and not a verdict, the power shifts. You're not just reacting, you're investigating. You're asking for proof, not just paying a bill. That's when I realized the best way to handle a vague violation notice is to demand specifics and keep your own records. If they can't show you the rule, the evidence, or a real signature, you have every right to push back. So what happens when the letter has none of that evidence? I started filming. If you want to turn the tables on an HOA that thrives on vague threats and shifting stories, documenting everything is your best defense. I learned this the hard way. After realizing their violation notice had no teeth, just paperwork designed to intimidate. The real power comes from 4 habits: record, save, timestamp, and compare. These steps aren't about paranoia, they're about building a wall of facts that's hard to knock down. Let's break it down. The first thing I did was start recording what happened around the lake, not just for drama, but to create a timeline. When the so-called community patrol started snapping photos of anyone near the water, I pulled out my phone and filmed them, too. Their reaction was immediate. They turned away, suddenly in a hurry to be somewhere else. That's when I realized, recordings don't just capture events, they change the dynamic. They make it harder for someone to rewrite the story later. But always check your local laws if you plan to record private conversations. Rules vary by state. Next, I got serious about saving every piece of communication. If the HOA sent an email, I moved it into a dedicated folder. Every voicemail got forwarded to myself, with the date and time written in the subject line. Flyers posted on my mailbox? I snapped a photo before the wind could take them. I labeled everything. It sounds tedious. But when the board sent a new letter claiming I'd ignored 3 previous warnings, I was ready. I checked my archive. There were no such warnings, not by email, not by mail, not even in my spam folder. I even scrolled through months of junk mail just to be sure. Nothing. That's when the value of timestamping hit me. Each record, email, photo, voicemail, had a clear date attached. The HOA's new letter listed dates for these supposed warnings. But none matched what I had. I matched their claimed warning dates to my receipts, and their dates didn't line up. The story the HOA tried to tell simply couldn't stand up to the facts. That's the moment the fear started to fade. I wasn't just hoping I was right, I could prove it. Background research backs this up. Every credible source on handling HOA disputes recommends the same first step: document everything and follow up in writing. You can't rely on memory or hope that someone else will keep track. The board counts on homeowners losing track of details or tossing out old letters. But if you keep a simple digital archive, emails, photos, voicemails, you have leverage. It's not about creating a mountain of paperwork. It's about having a clear, organized record that you control. There's a reason this strategy works. When the HOA tried to claim I'd been warned last June, I checked my files. No warning existed. I asked for proof. They said, "Our records show it was delivered." I replied, "Can you send me a copy? Or show me a delivery receipt?" Silence. That's how you know your documentation is working. The burden shifts. Suddenly, they have to back up their story, not just repeat it. If you're new to this, here's what I recommend. Whenever you get any kind of notice, flyer, email, voicemail, save it. Take a photo of any paper you receive, even if it seems minor. Move every HOA email into a folder, so you can find it fast. If you get a call, jot down the date, time, and who called. If you want to record a conversation or a meeting, check your state's recording laws first. But know that even just keeping notes and written summaries can make a difference. Recordings strengthen your case and make it harder for them to claim you weren't notified. Check your local laws on recording if you plan to record private conversations. I'll give you one example that changed everything for me. After a few weeks of saving and labeling every communication, the HOA claimed a new rule had been in place 4 years. I pulled out the earliest rulebook I had. Nothing about fishing, nothing about restricted lake access. I offered to send a scanned copy to the board. They declined. The moment I referenced exact documents and dates, the conversation got awkward. That's not a coincidence. The more organized your record, the less likely the board is to push a shaky claim. It's not just about emails and flyers, either. When the board said I was seen fishing on a day I knew I wasn't even home, I checked my phone's location data and calendar. I could prove I was across town. That's another layer of documentation, using digital footprints to back up your story. You don't have to turn your life into a surveillance operation. Just make it a habit to save what matters, especially when you sense a conflict brewing. Some people will say this is overkill. But if you've ever watched an HOA change its story from week to week, you know why it's necessary. At board meetings, the rules can suddenly appear or disappear depending on who's talking and who's listening. But when you have the receipts, emails, photos, voicemails, even a simple timeline, the facts are on your side. It's much harder for anyone to twist the story without getting caught. I remember the first time the board backed off mid-argument. I offered to forward a timestamped PDF of every notice I'd received. Suddenly, they wanted to review their records instead of pressing their claim. That's when I realized, whoever has the most organized record usually wins. You don't need a law degree. You just need to be able to pull up proof at a moment's notice. The real lesson is simple. documenting isn't about being difficult, it's about protecting yourself and your family. If you get a flyer, take a picture. If you get a call, write down the details. If you get an email, save it somewhere you can find it. When you compare your records to the HOA's claims, the truth becomes obvious. You're not just reacting anymore, you're building your own case, one piece of evidence at a time. But I also learned that documentation, while powerful, isn't always enough on its own. You can have every receipt, every email, every recording, and still face a wall if you're the only one speaking up. Sometimes, you need more than paperwork. Sometimes, the missing piece is a person, someone who's seen it all, who remembers how things used to be, and who can fill in the gaps the board hopes you'll never notice. That's what led me to start thinking about the people who'd lived here the longest, the ones who remembered before the HOA was even a thing. If there was anyone who could confirm, or challenge, the board's version of events, it would be someone who'd watched the neighborhood change from the very beginning. Sometimes, the most powerful evidence against a shaky HOA story isn't buried in city records or a law book, it's sitting in a neighbor's living room, collecting dust. That's what I found the day I visited Mrs. Chen. She's lived here longer than anyone, and her house feels like the neighborhood's archive. Old photos line the walls, kids fishing by the creek, block parties in front yards, and even a shot of the dam going up decades ago. Her coffee table held a stack of yellowed papers and a shoebox stuffed with clippings. I'd come with a folder of violation notices and emails. But what she had was something different, memories backed by real, physical proof. I didn't have to explain why I was there. She just motioned to a faded map pinned above her TV and said, "They used to call this public fishing." It was for everyone. That map was my first clue. It showed the creek labeled public fishing, community use only, with my street and lot right there. She said it had hung in the old community center before the HOA even existed. Next, she pulled out a petition, pages covered in signatures, some still legible, all from neighbors who wanted to keep the fishing dock open in the early 90s. The city had tried to close it once, but people pushed back. Last, she handed me a brittle letter from the county water office, stamped and dated, confirming the creek's status as community access and referencing public rights that predated the HOA by years. Those three things, a map, a petition, and a county letter, were more than just nostalgia. They were a paper trail that directly contradicted what the HOA claimed in their violation notice. I compared Mrs. Chen's map to my own deed, and the language matched. The petition and county letter showed that, at least until the 90s, public access was not only tradition but recognized by local officials. It wasn't just her word against the boards, there were signatures, dates, and stamps. I asked her if anyone had ever tried to make the creek private before. She nodded. Every few years, someone gets the idea. But the only thing that ever works is neighbors showing up with proof. She pointed to a photo of herself standing at a town meeting, waving the same petition I held in my hand. They forget. But we don't. Her stories were detailed. She remembered the year the dam almost broke and neighbors fixed it themselves. But the meeting where the board backed down after people brought in old documents. But she kept it simple. If you want to keep your rights, you need evidence. And you need people who remember. Long-standing historical evidence, especially recorded minutes, petitions, and government correspondence, can strongly support a homeowner's claim when an HOA's policy is newer or unrecorded. Mrs. Chen's artifacts weren't ironclad legal proof on their own, but they were persuasive. They showed a pattern of community use, and they gave me leverage if I needed to present a complaint to the board or even a city official. Most boards expect people to argue with feelings, not facts. When you show up with concrete items, a map, a petition, an official letter, it changes the conversation. I made notes as she talked, writing down every date and name she remembered. She even let me snap photos of the map and the petition. I didn't need every old newsletter or every faded photo on her wall, just the key documents that showed a history of public access, backed up by more than just memory. That's what I'd bring to the next board meeting if they kept pressing the fine. A lot of people think neighbor stories are just nice background noise, something to make you feel better but not useful when things get legal. But here's what I learned: when you combine first-hand accounts with dated, signed documents, you have a real shot at changing the board's mind. If you ever have to escalate, this kind of evidence also helps when talking to local officials or a mediator. It's not about winning a court case on nostalgia. It's about showing a pattern, a community standard, and a record of promises made and kept. Mrs. Chen's kitchen drawer was a gold mine. She had handwritten meeting minutes from the days before the HOA was formalized. One set of notes described a vote on creek access, unanimous, with every household present. She had a letter from the city water office, stamped and dated, confirming the creek was community access and not private land. She even had a flyer from the first fishing derby, open to everyone, with the HOA's predecessor listed as a sponsor. These weren't just stories, they were artifacts from a time before the rules changed. I realized the HOA's claim that fishing was always restricted didn't hold up. Their violation notice was just the latest in a string of attempts to rewrite the neighborhood's story. Mrs. Chen's evidence made it clear: public access was the norm, not the exception. Even if the board ignored her documents, I had something to show anyone who would listen: neighbors, city staff, even a local reporter if it came to that. Leaving her house, I felt a shift. Suddenly, my case wasn't just about my $500 fine. It was about a community tradition, backed by people who'd lived it and documented it. I had more than just a stack of emails and a copy of my deed. I had artifacts and stories that spanned decades. And a neighbor willing to back me up if things got heated. That changed everything. I wasn't just a single homeowner arguing over a technicality, I was part of a long line of people who'd stood up for the same rights. Most HOAs hope you'll never talk to someone like Mrs. Chen. They count on people forgetting, moving away, or giving up. But if you find even one neighbor with a memory, and a folder or two of old papers, you have a much stronger position. The board can ignore a complaint from one person. But it's harder to dismiss a pattern of evidence, especially when it's tied to official documents and community votes. I walked home with scanned copies of the map, the petition, and the county letter in my phone. I filed them in my digital archive, right next to my emails and violation notices. Now, if the board tried to press their claim, I could point to my deed, my records. If a neighbor's history that matched mine. That's the kind of backup you need, not just to win an argument, but to show you're not alone. Talking to Mrs. Chen made something else clear: I wasn't the only one who cared about these rules. There were others out there, maybe quiet, maybe tired of fighting, but still watching. Maybe all it would take was one person reaching out to start connecting the dots. That's how these fights get bigger than one fine or one angry letter. I started to wonder who else had stories, who else had proof, and what would happen if we started sharing what we knew. That's when I realized, if I wanted to stand a chance against the board's version of history, I needed more than just my own story. I needed allies. And I had a feeling I wasn't the only one ready to push back. It's easy to think you're the only one getting singled out when the HOA comes after you. For weeks, I walked around convinced I was the neighborhood problem, too persistent, too visible, too curious. But the moment Mrs. Chen showed me those old documents, I started noticing small signals everywhere: a neighbor's cautious nod, a quick question at the mailbox, someone glancing over their shoulder before whispering, "Did you get a letter too?" The isolation I'd felt started to crack. People who never used to make eye contact began stopping for a few extra seconds, hinting at their own run-ins with the board. The stories came out slowly. Alan, who lived 2 doors down, mentioned he'd been fined 3 times in a year, each time for something vague like improper mailbox maintenance or parking violation, but never with a photo or a bylaw cited. Another neighbor said she'd gotten a warning for unsightly landscaping, even though she'd just planted flowers. The pattern was always the same, a notice with recycled language, no evidence. And silence when anyone pushed back. Everyone felt alone. But the details matched up too perfectly to be coincidence. I invited Alan over one evening. And we spread out our paperwork on the kitchen table. His stack of violation notices looked almost identical to mine. The font, the signature block, even the phrasing, community standards, future violations may result in escalation, it was all recycled. We lined up our letters and started highlighting the overlaps. That's when it clicked, the board didn't bother to customize their threats. They just swapped out the supposed infraction and hoped nobody would compare notes. We realized the only thing keeping us isolated was silence. So we started reaching out, quietly at first. I texted a couple of neighbors who'd hinted at trouble. Alan mentioned our conversation to a friend on Pine Street who'd gotten a fishing fine. We didn't organize anything formal, just a few casual chats in driveways. Or a quick check-in after work. Each time, someone new would admit they'd received a warning or fine that didn't make sense. The fear was still there. But now it was mixed with relief. Nobody wanted to be the first to speak up, but everyone was tired of feeling alone. The real shift came when we started a group chat. At first, everyone was cautious, messages were short, full of disclaimers. And nobody wanted to look like they were leading a rebellion. But as we compared more letters, the patterns became impossible to ignore. One neighbor shared a screenshot of a violation about unauthorized gardening. Another posted a photo of a letter threatening loss of privileges for a car parked slightly over the line. We saw the same signature block, the same lack of evidence, the same vague threats. People began to realize the board was using a template, change the rule, keep the scare tactics. And hope homeowners never talk. With every new story, our confidence grew. We started trading scripts for how to respond to the board. Please provide the specific bylaw and evidence for this violation. Can you send the meeting minutes where this rule was passed? It wasn't about confrontation, it was about asking for proof. The more we compared, the more obvious it became that nobody had ever received a violation with real evidence attached. The few who had pushed back found their fines quietly dropped, with no explanation. A turning point came when someone invited a friend with legal experience to look over our letters. He wasn't there to give legal advice, just to help us understand what mattered. He pointed out that most of our notices were missing key elements: no bylaw citation, no date or time, no supporting evidence. And no real signature. This is all posture, he said. They're hoping you don't ask questions. That line stuck with us. We started keeping every letter, every email, every voicemail. Every time a new warning arrived, someone would post it in the chat. And we'd check it against the others. The recycled language, the lack of specifics, it was all there. We got smarter, too. One neighbor started photographing every notice board update, just in case the board tried to claim they'd posted a new rule. Another kept a running list of which newsletters mentioned new policies, and which didn't. Someone else tracked board meeting dates and who attended. It wasn't about building a case for court, it was about having facts ready when the board tried to bluff. The research backs up what we learned. Small collective steps, like starting a petition or gathering signatures, can shift the power dynamic with an HOA. We didn't launch a formal campaign. But we began talking about what it would look like to circulate a petition if things got worse. Just knowing we could do it made everyone feel stronger. If the board tried to change a rule in secret, we'd have enough people paying attention to push back. Even a simple group email with a list of signatures can make a board hesitate before sending out another round of fines. What mattered most was that we weren't alone anymore. The group chat became a place to swap stories, share advice, and compare notes. Someone would post, "Got another warning, anyone else?" and within minutes, 3 or 4 people would chime in with nearly identical letters. We learned to spot recycled language, to ask for evidence, and to keep every reply. The board's intimidation tactics only worked when people stayed silent and isolated. Once we started talking, the pattern broke down. We didn't turn into activists or start holding rallies. Most of our organizing happened in whispers, late-night texts, quiet conversations on the sidewalk, a quick glance at someone's phone. But those small steps made a huge difference. People who used to pay fines out of fear now asked for proof. Neighbors who never spoke up started saving their letters and forwarding them to the group. The more we shared, the less power the board's threats held. Sometimes, the best defense is just a handful of people comparing notes and refusing to be intimidated. We agreed on simple strategies: always ask for the bylaw, demand evidence, keep every document, and check with the group before responding. If someone got called into a meeting, they brought a copy of their paperwork and let the group know what happened. Even the quietest neighbors started to push back, knowing they had backup. Our small alliance didn't just protect us from bogus fines, it made us curious. If the board was willing to recycle threats and hope nobody noticed, what else were they hiding? We started digging deeper, looking for the original rules and documents that might explain how things had gotten so twisted. Every new discovery led to more questions. And the group chat turned into a kind of informal investigation team. The real power of a neighborhood isn't in the rules or the fines, it's in people talking, sharing, and refusing to be bullied alone. Every time someone spoke up, the board's grip loosened a little. We weren't out to pick a fight, we just wanted the truth. And with every new piece of evidence, every copied letter, every shared memory, we got closer. Then, as we compared notes and pulled our old paperwork, someone remembered an even older document, one the board never mentioned and nobody seemed to have a copy of. That's when things took a turn. Once we had the deed and the group, we found the big, old paper the HOA didn't want anyone to see. The biggest turning point came when we finally got our hands on the one document the HOA never mentioned, the original water rights deed for Willow Creek. This wasn't just another stack of bylaws or a newsletter with new community standards. This was the paper that spelled out, in plain language, who could use the water, who couldn't, and under what conditions. And it was signed and stamped by the county, years before the HOA was even a rumor. Pop Rodriguez was the one who had it. He's the guy everyone calls when something breaks around here, old school, sharp, and the neighborhood's unofficial historian. His house is a living timeline, toolboxes on the porch, faded photos on the fridge, and a kitchen table that's seen more neighborhood deals than the HOA ever will. When Alan and I showed up and asked about the original deed, Pop didn't hesitate. He reached under the couch, pulled out a thick, yellowed folder, and set it down between us. The paper inside was stiff, the ink still bold. Pop's hand shook a little as he opened it, but his voice was steady. "This is what they hope you never find." The deed itself was clear. It said, paraphrased, "All residents and their guests have the right to access and use Willow Creek for fishing, recreation, and livestock watering, except where county law says otherwise." It was signed by the original developer and stamped by the County Water Bureau. No mention of the HOA. No fine print about community board approval, just a straight-up grant of access, written before most of the houses even existed. That one sentence changed everything. It meant the right to use the creek wasn't something the HOA could invent rules about after the fact. The board's fishing fines and community guidelines were built on policies created years later. The deed was older, stronger, and had the county's seal right on it. In plain terms, the HOA's authority stopped where the original deed's rights began. We didn't spend hours reliving Pop's stories, just enough time to get the facts. He told us how. When the first HOA board tried to limit creek access, he'd shown them the deed, but as new people moved in and boards changed, the story faded. The association kept making up new rules, counting on nobody digging through old paperwork. That's how they kept control, by hoping history would stay buried. I took pictures of the deed right there at Pop's table, texted them to the group chat, and watched as the mood shifted. Suddenly, the anxiety and second-guessing vanished. People started talking about the next step. We all understood, a county-stamped deed isn't just a piece of nostalgia, it's a legal document that can override later HOA rules, especially when it's on file at the courthouse. But here's the important part, even with a deed like this, you can't assume you've automatically won. The law gives recorded deeds and easements a lot of weight. But the outcome always depends on your local statutes and the exact wording. Some states protect these rights more than others. If you're in this situation, use the deed to request clarification, ask for a meeting, or file a formal inquiry. Don't just wave it around and expect instant results. With the deed in hand, we got practical. We scanned the document, saved high-res copies in our shared folder, and made sure everyone in the group had access. We drafted a formal letter to the board, no drama, no threats. Just the facts. We have reviewed the original county-stamped deed, which grants all residents access to Willow Creek for fishing and recreation. This right predates the HOA's current policy and is supported by the attached document. Please clarify the legal basis for any restrictions or fines you are issuing, and provide copies of any county or city ordinances that override the recorded deed. We are also sharing this correspondence with the city clerk and council for full transparency. We kept it simple and direct. No accusations, just a request for the board to explain themselves in light of the actual legal record. We attached photos of the deed, the county seal, and a copy of the old petition Mrs. Chen had shown me. We CC'd the city clerk and a council member, just so the board knew we weren't bluffing or acting alone. If you're going through something similar, this is the move: gather your evidence, organize it, and send a clear, fact-based letter to the board and local officials. Don't just argue, present the paperwork. The response from the board was immediate, but not what we'd seen before. Instead of more threats or generic policy quotes, they replied with a request for a meeting. No mention of fines, no escalation. Just, we would like to discuss the matter further. That's how you know you've hit a nerve, not because they back down instantly, but because the conversation shifts from threats to negotiation. We didn't celebrate or assume we'd won. We kept documenting every step. We saved every email, every voicemail, every piece of correspondence. We updated our group folder with the deed, the petition, old maps, even screenshots of the board's previous letters. We agreed on what to say if anyone was approached individually. And we waited to see if the board would try to push back or quietly let the issue drop. What changed most was our confidence. The group wasn't just a handful of nervous homeowners anymore. We had proof, real, dated, county-stamped proof. The board's claim to control the creek was undermined, not by angry words, but by a document that predated their authority. That's the key. In any HOA dispute, the oldest recorded document with an official seal usually carries the most weight. But always remember, bring your paperwork, ask for clarification, and be ready to show your evidence to a third party if needed. It's tempting to think a single document will solve everything overnight. The reality is, it's just one piece of a bigger case. The deed gave us leverage, but we still needed to organize, communicate, but follow through. We didn't threaten lawsuits or demand resignations. We just showed up with the facts, asked for answers, and let the paperwork speak for itself. If you're facing an HOA that's overreaching, start with the basics, check your deed, look for county records, and talk to the neighbors who've been around the longest. Scan everything. Share it with your group. Use it in your letters. And always keep your communication clear and on the record. The more organized your evidence, the harder it is for anyone to ignore you. We weren't legal experts. And we didn't have money for a lawyer. But with the deed in our hands and the group working together, we were finally ready to build a case the board couldn't brush off. The next step was to see if regular people, without legal training or deep pockets, could actually hold their own against a board that seemed untouchable. Building a case the HOA can't ignore starts with one simple step: get your paperwork in order. We didn't try to out-argue the board or make speeches at meetings. We started by scanning Pop's deed, the one with the original water rights, county stamp, and signatures. That document went straight into a shared folder, along with every old map, petition, HOA notice, and email we'd collected. Alan set up the folder online so everyone in our group could access it from their phones. We gave each file a clear name: willowcreek_deed_original.pdf, violation notice April 2024.jpg, county letter _1992.pdf. It wasn't fancy, but it was organized. If you're facing an HOA, this is where you begin: scan everything, label it, and store it somewhere you can reach fast. Once we had the folder, we met at my kitchen table, just neighbors, coffee, and a stack of manila folders. We didn't need a lawyer to tell us what to do next. We laid out the deed, clipped together our matching violation notices, and compared every letter for recycled phrases. Doug kept a running log on a notepad: date, sender, what the letter claimed, and any missing details. Lydia brought in photos from her drone, shots of families fishing at the creek, even though the board claimed no one uses it. We checked every flyer and email for real bylaw numbers and found nothing. That's when it hit us: the board was hoping nobody would ever look this closely. Our next move was the turning point. We drafted a formal letter to the HOA. It wasn't angry or dramatic, just calm, clear, and packed with facts. We listed every place the board's violation notice conflicted with our deed and county law. We attached the water rights document, the old city letter confirming creek access, and screenshots from our group chat showing nobody had ever received notice of the so-called new rules. We CC'd the city council and the city clerk. The letter ended with a simple request: please provide the specific bylaw or ordinance that overrides the attached deed, and share any meeting minutes where this rule was passed. That was it, no threats, just a documented question the board couldn't brush off. If you're dealing with your own HOA headache, here's the roadmap we followed: scan your deed and any other official documents, organize all violation notices and communications, write a calm letter to the board with your evidence attached, and CC a local official or city clerk for transparency. Start with a documented letter and escalate to asking for board minutes or legal counsel only if necessary. Research backs this up: written communication is your safest first step, and you only need to bring in a lawyer if things get legal or the board refuses to respond. The response from the board was different this time. Instead of another generic threat, we got an email from their attorney, someone we'd never heard from before, asking for a meeting to discuss amicable resolution. The tone had shifted. There was no mention of the fine, no more escalation, just a request to talk. A few days later, word spread that the board president had resigned. The rest of the board stopped sending new violation notices. Our fine was dropped, and the threats faded out. I want to be clear: not every group will see the same results. Laws and outcomes vary by state, and some boards dig in when challenged. But in our case, having the right documents and a clear, organized record forced the board to take us seriously. After that, neighbors who'd never spoken up before started reaching out. Some had paid fines they now realized weren't backed by any real rule. Others brought their own stories and paperwork, old newsletters, meeting minutes, even photos of the creek from years ago. Our shared folder grew. And so did our confidence. The mood in the neighborhood changed. People started talking openly about their experiences, asking each other for help, and sharing tips on what to do if they got another notice. The board's intimidation tactics lost their grip, replaced by quiet conversations and a steady stream of evidence. The board did try one last move, a closed-door meeting to address growing unrest, but now, with city officials looped in, the old threats didn't land. The HOA's lawyer sent a note about working together constructively going forward. It wasn't a surrender, but it was a clear sign that our documentation and unity had shifted the balance. We kept things practical. Every new letter got scanned and shared. Every meeting was logged. If someone got called in for a conversation, they brought copies of their documents and let the group know what was discussed. I want to emphasize, none of us were legal experts. We didn't have special connections or money for a big lawsuit. What we did have was proof, scanned, labeled, and shared. We tracked every interaction, every threat, every reply. We never assumed the board would back down. We just made sure every step was recorded and every question was asked in writing. That's what made the difference. Not a single dramatic confrontation, but a series of small, careful steps that added up to real leverage. If you're watching this and wondering if you could do the same, here's what matters: don't try to fight alone. Start by organizing your own documents. Find 1 or 2 neighbors willing to compare notes. Scan everything: deeds, letters, emails, even old flyers. Write a calm, fact-based letter to the board and CC a city official if you can. Ask for the specific bylaw or meeting minutes behind any rule they try to enforce. If the board tries to escalate or brings in a lawyer, keep everything in writing and consider consulting an attorney who knows HOA law. But don't jump to legal threats. Most disputes can be resolved with clear documentation and steady pressure. The most important thing we learned was that silence and scattered facts protect bad behavior. When you gather evidence and share it, the board can't ignore you. Our story didn't end with a big courtroom drama or a public showdown. It ended with the board changing their tone, a resignation, and the fine quietly disappearing. The mood on our block shifted from anxious to hopeful. People started to believe they could stand up for themselves, not because they wanted a fight, but because they finally had the tools to do it. And that's where things really started to change. What began as a single $500 fine turned into a new way of looking at every rule, every letter, every so-called violation. The more people got involved, the more the old habits of silence and fear broke down. Our neighborhood didn't transform overnight, but it did start to feel different, more open, more connected. But a little less afraid. What happened next surprised me. The story of our little group and our creek spread faster than any violation notice. Neighbors started sharing their own stories. And the board realized they couldn't just rely on quiet threats and hidden paperwork anymore. It all started with one well-organized pushback. When the fine disappeared, something bigger took its place. What started as a personal fight over fishing rights became the talk of the whole neighborhood. The board's old way of operating, quiet, closed-door decisions, threats tucked inside official-looking letters, suddenly felt exposed. People started trading stories at the mailbox and after community meetings. It wasn't just about one creek or one family anymore. It was about how rules got made, who enforced them, and what counted as fair. The shift happened fast, but not by accident. Lydia's drone video of the otters in Willow Creek made the story real for a lot of people. The clip didn't go viral nationwide, but it did amplify local attention and put real pressure on the board. Neighbors who'd never spoken up before started sharing their own violation letters, old maps, and copies of fines. The group chat grew. Local reporters started calling, asking why the board's story didn't match the documents neighbors had collected. Suddenly, the board wasn't just dealing with a few troublemakers, they were facing questions from the press and a neighborhood that could prove its case. You could see the cause and effect in real time. Lydia's otter video got people talking. That conversation turned into neighbors comparing evidence. The local press picked up the story and started asking tough questions. The board got defensive, scrambling to update policies and justify old decisions. Some members tried to explain themselves at meetings. But the explanations didn't hold up. Within a few weeks, board resignations started coming in, short, clipped notes thanking everyone for the opportunity to serve. The board's grip loosened. And the old guard faded out. That's when the real change began. New people ran for the open seats, people who'd been in the group chat, people who'd asked for evidence and gotten silence, people who wanted the rules to make sense. They promised to post budgets online, hold open meetings, and actually respond to questions with facts instead of form letters. The meetings moved out of stuffy offices and into the open, sometimes literally under the gazebo by the creek. Instead of fighting over mailbox colors or threatening fines for sidewalk chalk, neighbors started talking about fixing broken sidewalks and planting new trees. The focus shifted from punishment to improvement. The transparency made a difference right away. Every budget, every policy change, every meeting agenda went online for anyone to see. People could ask questions and get real answers. The board stopped sending out vague warnings and started explaining the reasoning behind every decision. Fines for fishing, mailbox colors, and harmless decorations were revoked. The board even issued an apology for the confusion and stressed the old policies had caused. For the first time, people felt like they had a say in what happened where they lived. The story spread, first through word of mouth, then through social media, then finally in local news. Neighbors from other subdivisions reached out, asking how we'd done it. Families who'd been too nervous to speak up started sending messages, asking for advice on writing dispute letters or requesting copies of the group's template emails. The new board shared the blueprint, document everything, compare notes, and demand transparency. The message was clear: when you organize and keep records, the board has to answer for its decisions. Looking back, it's strange how quickly the mood changed. People who used to avoid each other at the mailbox now stopped to chat. Arguments at meetings turned into real discussions. Instead of feeling isolated, neighbors realized they shared the same frustrations, and the same power to do something about them. The old fear of getting singled out faded as more people joined in. The kitchen folder of evidence grew into a neighborhood archive, filled with old deeds, letters, and photos from every block. The media attention didn't guarantee success, but it amplified what was already happening. The real shift came from neighbors working together, sharing documents, keeping records, and refusing to accept vague threats as the final word. The research says it best: lasting neighborhood change usually comes from a mix of documentation, coordinated action, and clear demands for transparency. When you insist on open budgets, accessible meetings, and honest answers, boards have a much harder time hiding behind closed doors. The new board's first act was to invite everyone to an open meeting by the creek. No more closed sessions, no more secret votes. They answered questions, explained the rules, and listened when people brought up problems. The mood was cautious, but hopeful. People brought their kids, shared snacks, and talked about what they wanted the neighborhood to be. The otters came back, and so did the sense that this place belonged to all of us, not just a handful of people with a rulebook. The biggest surprise was how simple the first steps really were. It didn't take a lawyer or a viral video to get things moving. It took a few people willing to save their letters, ask questions, and talk to their neighbors. The more we documented, the more we shared, the less power the board had to intimidate anyone. The new board posted every budget and meeting agenda online. They sent out clear notices and started answering emails with real information. The fines and threats faded away, replaced by real conversations and a sense of trust that hadn't been there before. If you're watching this because you're dealing with an HOA that feels impossible, know this: you don't have to go public or call the media to make a difference. It can start with a quiet conversation, an old map, or a single email asking for the rule in writing. When you save your documents and connect with just one other person, you start to build the kind of case that's hard to ignore. Most boards aren't used to being questioned. When you organize and ask for transparency, you force them to act like the public servants they claim to be. What happened here wasn't magic. It was the result of people refusing to be quiet, refusing to pay a fine just because it was easier, and refusing to let someone else decide what their neighborhood should be. Every step, filming the orders, saving the letters, sharing the evidence, asking for open meetings, added up. The board changed because neighbors demanded it, not because anyone handed them power. And the creek, the meetings, the way people looked out for each other, all of it was stronger than any fine or threat. A single refusal to be quiet became the reason neighbors started demanding transparency. If you're just starting out and wondering what it actually takes to protect yourself from an HOA that overreaches, let me break it down. You don't need a law degree. And you don't have to memorize a stack of bylaws. What you do need is a clear, simple process. I wish someone had given me this list the first time I opened my mailbox to find a $500 fine. Here are the 5 steps every beginner should take, the exact moves that made the difference for me and my neighbors. Step 1. Pull your deed and CC&Rs, check recorded rights. The first thing you want to do is find your original property deed and the covenants, conditions, and restrictions, CC&Rs, you got when you bought your home. Don't start with the latest HOA newsletter or the pile of flyers about meetings. Go straight for the documents with signatures and stamps, the ones that spell out your rights, like access to the lake, use of common space, or what you actually agreed to when you signed at closing. Put your deed side by side with any violation notice you've received. Look for the exact language about what you can and can't do. If the violation notice doesn't quote a bylaw or cite a real rule, just says community standards or as determined by the board, that's a red flag. Your deed and CC&Rs are your foundation. They're what the board should be referencing, not just vague policy. Step 2. Save everything: email, flyers, photos. Every piece of communication from the board matters. Move every HOA email into a dedicated folder in your inbox. Snap a photo of every letter or flyer, even if it looks like junk. If you get a voicemail, save it, and if you can, forward it to yourself so it's backed up. If someone posts a notice on your door or mailbox, take a picture before it disappears. The board expects you to lose track or forget the details. Don't give them that advantage. Having a record of every message, flyer, or call means you can spot patterns, catch contradictions, or prove what was really said or sent. Step 3. Record interactions, time, date, summary, or voicemail. Whenever you have a real exchange with someone from the board, whether it's a phone call, a chat at a meeting, or even a quick conversation on the sidewalk, make a record. If it's a call, let it go to voicemail if you can. Or write down the date, time, or a quick summary of what was said as soon as you hang up. If you talk in person, jot down a note in your phone or a notebook right away. If you feel comfortable and local laws allow, record the conversation. Even a simple voice memo helps. The point is to create a timeline. When stories change or the board claims, "We already told you," you'll have proof. And when they know you're documenting, they're more likely to stick to the truth. Step 4. Ask an experienced neighbor. Local history matters. Find the person on your block who's been around the longest. This isn't just about nostalgia. Long-timers usually know which rules are old and which ones were invented last year. They might have original meeting notes, old petitions, or even city letters from before the board got strict. Ask how things used to be handled, and if they have any paperwork or memories that back up your case. Sometimes, a single old map or letter can change the whole conversation. These neighbors are your link to the past. And their knowledge can fill in gaps the board hopes you'll never notice. Step 5. Find one ally. Compare notes quietly. Don't go it alone. Quietly reach out to another neighbor who's gotten a violation letter or seems frustrated by the same issues. Meet for coffee, a walk, or just a quick chat in the garage. Show each other your paperwork. Compare the language in your violation letters, the response times, and any patterns you notice. When you see that the same recycled phrases appear in multiple letters, or that fines are being handed out for the same vague reasons, you gain power. Even one ally doubles your ability to push back and spot trends. If you can, start a simple group chat or email thread to keep sharing updates. The research repeatedly recommends, know your governing documents, document responses in writing, and start petitions or collective action when needed. These aren't just tips, they're the backbone of every successful pushback against overreaching boards. The boards that get away with intimidation usually count on homeowners not knowing their rights, not keeping records, and not talking to each other. When you do these 5 things, you flip the script. Why does each step matter? Pulling your deed and CC&Rs means you know what rights you actually have, not just what the board claims. Saving everything gives you a paper trail that can't be rewritten. Recording interactions keeps people honest, stories don't change so easily when there's a record. Asking an experienced neighbor brings in evidence and context the board can't erase. And finding an ally means you're not isolated, you're building a network, even if it starts small. These steps aren't about picking a fight, they're about protecting yourself and making sure the board follows its own rules. Check local rules. HOA powers vary by state, so use your deed and local ordinance as your guide. Some places give boards more authority, others protect homeowners more strongly. If you're not sure, contact your local city clerk or a real estate attorney for a quick review. But don't let uncertainty freeze you. Even in strict states, these 5 steps put you in a stronger position than most people ever reach. You don't need to be loud, confrontational, or an expert to do this. Start with your own paperwork. Make a folder. Talk to just one neighbor. Every time you save a letter or compare notes, you're making it harder for the board to rely on vague threats or shifting stories. If you get a violation notice, don't panic or pay right away. Check your documents, save every message, and ask questions. If you get a second letter, compare it to the first. If you see a pattern, talk to someone else who's gotten the same treatment. These are small moves, but they add up fast. I've seen neighbors go from feeling powerless to confident just by following these steps. The first time you show up at a meeting with your deed, your saved emails, and a timeline of what's happened, the conversation changes. The board can't just wave away your questions or hope you'll forget. When you and a neighbor both have records and know your rights, it's much harder for anyone to push you around. Remember, you don't have to win every fight to make progress. Each step you take, saving a flyer, asking a question, comparing a letter, builds a foundation. The more you do, the more you'll see patterns and the easier it is to push back. Even if you don't get the perfect outcome, every single step forward builds something bigger. Real progress with an HOA doesn't start in a courtroom, it starts at your kitchen table, with a folder of letters and one neighbor willing to listen. Small wins matter. Each time you document, compare notes, or ask for a bylaw in writing, you make it harder for the board to rely on vague threats. Tell me in the comments where you are and if an HOA's ever overreached. I'll read them all. If you want more practical neighborhood justice stories, hit subscribe. If you take one thing from this video, let it be this: document first, ask second, and find one neighbor to compare notes. Start tonight.